State of Kansas versus Antonio Manuel Perez Beal. Counsel, state their appearances, please.
May it please the court, the state appears by Jill Gillette.
You, Antonio Manuel Perez Beal.
Yes, sir, I am. Yes, Your Honor, I am.
All right. Mr. Perez Beal, do you have an attorney?
No, I do not. But I do believe I have the right to face my accuser.
Here we go again. The classic sovereign citizen performance. The judge is simply trying to explain the charges, yet instead of giving a clear yes or no, the defendant dives straight into, for the record, theatrics. Within seconds, he pivots from answering questions to demanding the case be dismissed. It's textbook defiance. Muddy the waters, question the court's authority, and stall the inevitable. A tired strategy built on confusion, not conviction.
On the record, for the record, and let the record show, I have the right to face my accuser, and the accuser must be a living man or woman.
Stop.
Therefore, I move to dismiss the case entirely.
Well, that's not going to be done. Mr. Perez Beal, I asked you a question. Do you understand what you're... All right. What is it that you don't understand about the criminal trial?
This is pure chaos. He's not defending against the trespass charge. He's trying to turn the entire case upside down. In his version, a broken fence and missing livestock somehow give him the authority to throw out his own criminal charges. It's a complete breakdown of logic. What he fails to grasp is simple yet absolute. Shouting, dismissed, doesn't make a judge disappear, and no amount of personal grievance can rewrite the rule of law.
And my children over there on November 23rd or 27th, I'd have to go back and date it. My livestock, please let me finish, Your Honor. My livestock come up missing. Whenever that man, I had that leased. Whenever that man come over here, down here, my hot wire come up missing. The fence that divided our two properties. He cut a hole in his fence. I have a witness who is a neighbor stating that he's seen a young man out there removing that hot wire. I've never once had a problem. He showed up, our hot wire come up missing, and a hole got in the fence. Whenever that happened, I called one of your deputies.
Did you catch that? The defendant actually tries to file an interim appeal, right there in his very first appearance. The legal equivalent of appealing before the game even begins. It's a move straight from the sovereign citizen playbook, tossing out random, Latin-sounding jargon that has no basis in real law, hoping it sounds official enough to create confusion. But judges have heard it all before. The language may sound impressive, yet it carries no legal weight at all.
In a criminal case is beyond a reasonable doubt. At a trial, you have the right to be represented by an attorney or to represent you. Understand you have the right to, at a trial, to cross-examine the state's witnesses and to call witnesses on your own behalf. You may use the court subpoena power to be sure that other witnesses appear. Do you understand these rights?
Yes, sir.
All right. Now, at a trial, beyond the right to cross-examining the state's witnesses and calling witnesses on your own behalf, you have the right to either testify or not testify as you see fit. If you choose not to testify, then then that cannot be considered against you into determining if you're guilty or not.
And here it comes, the greatest hit of the sovereign citizen routine. Must my accuser be a living man or woman? It's a classic line pulled straight from their script, where they twist the Sixth Amendment into pure fiction, claiming that governments and corporations don't legally exist. Yet the judge stays composed, unshaken, responding with quiet authority. I'm not sure where you're getting this. In that calm dismissal lies the truth. Real law doesn't bend to fantasy.
Still on probation?
Yes, sir. As far as I know.
Well, if you're on probation and convicted of a new offense, that'll be a violation of that probation.
That's why Miss Gillette is doing this. My attorney already told me Miss Gillette does not like me. That comes from Miss Gillette to my attorney. That's a conflict of interest.
Right now.
Now he's spiraling into conspiracy, accusing the prosecutor of tearing families apart. At this point, the courtroom feels less like a legal proceeding and more like an emotional outburst disguised as testimony. But the law doesn't bend to feelings or accusations. None of it changes the facts. He's charged with trespass, not here to relitigate his neighbor's actions or the prosecutor's intentions. The judge stays focused, because no amount of deflection can rewrite what's actually on trial.
An attorney but cannot afford an attorney, you can apply to the court. If you meet the financial guidelines, then I would appoint an attorney to represent you. Now, that may not be an attorney that you select.
I will talk to Miss Mary Ann Shirley.
All right. So if you're going to talk with an attorney, typically what we do is we schedule another hearing to give you that opportunity. And we call that a control hearing or a status. Do you wish to do that, or do you wish to go ahead and schedule a trial?
If we schedule a trial and I show up with an attorney, will that be allowed?
Well, it would, but if you're asking for a jury trial, there's certain things that you have to do. Right now, you're representing yourself. That can be, you need to understand that the disadvantage that people have by doing that sometimes is more than others, but you will be required to follow the rules as you are an attorney if you're representing yourself. Most people don't know what those rules are and so forth. So that presents a real disadvantage at times. Do you understand that?
Yes, sir. This part is genuinely heartbreaking. The judge patiently outlines the risks of self-representation, offering clarity and compassion. And then the defendant's words cut through the chaos. I'm just trying to keep our home and stay afloat. Beneath all the sovereign citizen jargon lies something raw and human, a man trapped by fear, frustration, and desperation. It's not rebellion driving him, but a sense of being cornered and unheard. The tragedy is that his plea for help is buried beneath arguments that only push him further away from real relief.
So you're going to apply for an attorney or talk with Ms. Shirley, what I'll do is schedule a control hearing. That is not waiving your right to a trial, all right? If that control hearing or status conference, which we'll set in about 30 days, if you still wish to have a trial, we'll schedule that. We can schedule for either in person, either before the court, or you can be represented. If you wish to have a jury trial, you need to have your request made in writing for that. And we would schedule a trial by jury. There was a hearing that was scheduled on December 13th, and you did not appear at that time. I issued a bench warrant, and you had been served with a summons. Now, later that day, you contacted the clerk's office, and then you did surrender yourself and posted a $5,000 cash or surety bond, and that bond is still in effect.
Yes, Your Honor.
So
Yes, Your Honor.
You need to be sure that you appear.
This is the judge's quiet but powerful warning. Missed court dates lead to bench warrants, and bench warrants mean cash bonds and jail time. It's a glimpse into how fast these cases spiral out of control. What begins as a simple trespass charge can snowball into probation violations and jail cells, all because someone refuses to follow the basic rules of the system. One act of defiance becomes a chain reaction, and the law doesn't pause for stubbornness.
Can you hear me fine now?
Well, it comes and goes. Right now, yes, I can hear you.
Can you hear
Now we can't hear you.
me now?
There's also a time delay. I'll see your lips move, and then we'll hear the sound. We call it lag, or I call it. Mr. Perez-Beal, now you're frozen, and we haven't been able to hear you for the last 30 seconds or so.
I'd just like to make a statement.
Well, you've made some statements, but
Can you hear me
right now we're scheduling January 31st.
How about now? Are you able?
Now I was able to hear you. You interrupt me, but our next court hearing is January the 31st at 3 p.m.
By the end, the judge has no choice but to mute him, and that moment says everything. When your courtroom defense becomes so chaotic that they have to cut your mic, it's not strategy, it's surrender. This case perfectly captures the inevitable clash between sovereign citizen theatrics and real law, a loud, defiant voice silenced by the simple weight of order, logic, and authority.
So that we don't have this problem here. If you have an attorney and the attorney would prefer to have you there at their office to do the hearing. So if Ms. Shirley is going to be your attorney, you hire her and she wants you to be but you need to be at one of those two places, either the attorney's office or at the sheriff's office where they have the equipment, and we can be relatively sure that you're going to have a good connection. Because in this hearing, we haven't had.
Yes, sir.
All right. That's the things that we needed to cover for today. So this matter will be adjourned, and we'll see you on January 31st at 3. So Mr. Presbeel's case is adjourned at this time. All right. Next matter we'll take up is